Welcome to Court Beacon TV, where we shine a light on justice, stay informed, and stay empowered.
You were gainfully employed. You were trying to be the best citizen you could.
Best dad, best brother, best son, best everything I could be. I wasn't trying to be the person I am now. You know what I'm saying? It was from 21 years ago.
And you would have been gainfully employed except you got hurt on the job. Is that correct?
Yes, I am. I'm legally disabled too. My right wrist got my hand crushed by some pipe.
And in fact, you're still
A man
awaiting-
who admitted his past, served years in prison, and tried to rebuild his life. But when he stood before Judge Boyd, a 20-year-old case came back to haunt him. What the judge said next changed everything.
2 CR 6777, State of Texas versus Tremonte Singleton. Can I have parties announced for the record for the state,
Brittany Mitchell for the state.
for the
Dave.
defense?
David A. Garcia, attorney for Tremonte Singleton, Judge.
And are you Mr. Singleton?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years. The state opposes your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
We have.
All right. Any objections, state?
No.
Defense?
Judge, the only thing that I would add is it's left out that one of his priors was out of Houston. And it was a indecency where he served 5 years prison.
Okay.
I wanted to bring that up because my clients can talk about that. Secondly, when they asked about the incident, because it was 21 years ago,
Mhm.
my client was kind of in shock trying to remember, but, and you'll hear from him when he testifies, Judge, but he's very sorry about what happened. And that was left out of the PSI report. Other than that, we have no objections.
Okay. State, do you have any witnesses?
We do not, Your Honor.
Defense, any witnesses?
No witnesses in person, Judge. I tendered to both the state and to your clerk 4 letters from family members.
And the court is in receipt of the letters. Any objections to the court reviewing those letters, state?
No, Your Honor.
All right, the court will review the letters. The court has reviewed the letters. Any argument from either side? State you're opposed?
Well, Judge, my client would like to speak.
Oh, okay. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record, please.
Tremonte Singleton.
All right, defense?
Tremonte, you stand now before the judge. This incident happened back in 2002, correct?
Yes, sir.
Never once when we talked from the first moment that we met till today, did you ever intend to fight this case? Is that correct?
No.
Because you knew you did it.
Yeah.
And in fact, you went to prison out of Houston from 2009 to 2014, correct?
Yes, sir.
For an incident that occurred in Houston
Yes. But they,
back in 2002. Okay, and while they were investigating that incident, you also got notice that they were investigating this incident out of San Antonio, correct?
Right.
Okay. So when you took your plea in Houston, you had never met me, right?
no, sir.
And so you took your plea in Houston, you did your time, you did almost the whole 5 years, correct?
I did the whole 5.
And when you got out, you thought both of these cases were long gone, correct?
Your Honor, I object to leading.
All right, that'll be overruled. You may
I'm just
continue.
trying to speed things up good. So when you were arrested on this charge, you were shocked, correct?
Yes.
In fact, wasn't that basically what you were telling me the first time we met? You couldn't
Yes.
believe that this was happening, that was in your past and you thought you had taken care of everything.
What I would like to say first, I apologize. And I'm very sorry to the victim if I hurt him or anything caused any harm in their life. I sincerely apologize for it. But when I was arrested in 2009, I was made aware of this case. And all I wanted to do was just get everything out the way. And I asked them about when was I coming back here to face punishment or whatever for this case. I went through 5 years, never got expedited, never got a bench warrant from TDC, never had a detainers from the wall. I stayed out another 8.5 years registered, done everything I had to do, and I didn't know that this case was still about until they picked me up in 2022. And I had asked them about this particular case way back then, and there was never no orange, no nothing until now.
Now, Tremonti, when you said you reported as this
Yeah.
from 2014 up to 2022, correct?
Yes.
You never got into any trouble from 2014 to 22.
No, sir.
Okay. During that time period, you had children, didn't you?
Yes.
You had a job. You were gainfully employed.
Yes.
You were trying to be the best citizen you could.
Best dad, best brother, best son, best everything I could be. I wasn't trying to be the person I am now. You know what I'm saying? It was from 21 years ago.
And you would have been gainfully employed except you got hurt on the job. Is that correct?
Yes, I am. I'm legally disabled until my right wrist because I got my hand crushed by some pipe.
And in fact, you're still awaiting surgery on your elbow, aren't you?
Yeah, elbow.
You receive about what, $1,500 to $1,600 a month on disability?
Right at $1,600 a month from Liberty Mutual, being disabled.
And you have 5 children,
5.
2 of which you are intimately involved with,
Yes,
helped raise.
yes, sir.
How are those kids doing in school?
Doing great.
One of them's honor roll,
Yeah, tonight
your
is
16-year-old,
Tonight is on the road. So,
and your younger son, he's making good grades,
yes, sir.
A's and B's.
Yes, sir.
The other 3 kids, you don't have as much involvement because of their mother, correct?
Exactly.
But do you try to help support them?
Of course, yes, sir.
Anything you can.
Best I can.
Okay, now you know the judge can send you to prison for up to 10 years,
Yes, sir. I understand that.
or she can give you deferred adjudication for up to 10 years.
I understand that.
If she were to give you deferred adjudication, why would she do that? You have this horrific past. Are you the same person you were back then?
No, sir. I'm not the same person I was.
Does the fact that you've stayed out of trouble since 2014 help show that you're a different man?
I would like to think that, but like I said, it's only, you can go by only so much, you know what I'm saying? I know in my heart that I'm not that person from 14 years ago. I never want to go back to being that person.
Would you do anything the judge requires you?
Anything.
If she sends you to jail, you understand,
I understand that.
and you respect that. But you're hoping she gives you this opportunity. I'll turn to the witness.
State.
Mr. Singleton, who is the victim in the case from Harris County?
Her name is Nick. Yes.
What was your relationship to her?
Didn't have a relationship. Me and her stepdad, we were kind of like friends.
So were you a family friend of hers?
No, not a family friend of her. Just knew just like living in the same neighborhood and stuff, but I didn't know her.
Was it a similar situation as this case where you assaulted her in public? So this happened in a home?
Yes.
What, you were in a position of trust?
You per se, yeah.
Okay. And how old was she?
15.
Okay. So she was the same age as the victim in this case.
Yes.
And you didn't know the victim in this case, did you?
No, I didn't even know her age until after I got arrested here.
Okay. Now, you knew you had committed this crime, right? When it happened, you knew it was a crime.
I didn't know that I got charged with this crime until 2009 when they questioned me about it. I didn't actually know that I was even charged with this until I got arrested.
So you thought you got away with it until you were arrested for it?
I thought I got away with it. I just never thought it was. I was never arrested for it, so I didn't know that.
Objection non-responsive.
All
You
right.
knew it was a crime when you raped her in 2002.
I didn't. Well, if that's what you want to say, yes.
Okay. So did you go to the police in San Antonio and turn yourself in and say,
No, because their circumstances of what they're saying and what I need to be the truth never got put out there. I was never interrogated, not even here, not even in Houston. Barely, they just asked me a few questions about it. I was never interrogated. I was never able to tell my side of the story.
okay, so now you're saying that you weren't actually, it wasn't an investigation and you knew that the charges weren't actually pending.
No, I didn't know that. No, it was an investigation or nothing. I didn't know nothing about this case until I got to Harris County. When I got arrested in 2009, I didn't know nothing about this case.
Okay. It wasn't until 2021 that San Antonio Police Department actually came and served you with a warrant to get a sample of your DNA, correct?
No, they did not get an initial warrant out to get a sample of my DNA. They already had my DNA in 2009 when they questioned me. They had already had my DNA.
Are you saying they didn't come and get another swab out of your mouth?
No. No, they did a yearly swab. As,
Okay.
a yearly swab as I was registered. But
Okay,
they already had my DNA in 2009 when they questioned me. Because that's how I got alerted to the case in 2009 when they told me that I had a DNA match back then, 14 years
in
ago.
2009, did you try to find out the name of the victim from 2002?
They told me tonight.
Did you ever try to reach out and apologize to her?
No, I was being incarcerated at the time. I was on my way to.
Did you make any attempts?
Not make any. I didn't know. I barely even knew. That was like you talk about something that happened in 2002. This is 2009. I'm talking about it was 7 years before I wasn't even in San Antonio at the time.
Okay, but you got your GED while you were incarcerated, correct?
Yes.
So you had access to people who knew how to look into information. People from the outside world.
I'm going to object to vague, Judge.
All right, well, this is the question the court has. I want to know why a charge that happened in 2002, and I understand the on or about dates and the indictment is on or about 2022, but I want to know why something that occurred in 2002, he's in prison, everybody should know where he is, he's at the prison. Why is this just being addressed now? That's what I want to know.
So Judge,
no.
we discussed that. I discussed it with my client. I discussed it with the state. I told my client that we could file a motion for speedy trial, that the detectives, the state dropped the ball, that this all should have been taken care of back then. But he did not want to do that. He knew he had done it, wanted to go forward, but just wanted to let you know that he had spent 5 years in prison thinking that all of this was taken into consideration when it clearly wasn't. And so I think that's one of the reasons why the state made this offer, because we discussed this, we worked everything in, but we wanted to bring it to your attention so that you knew that that was an option. He didn't want to go with that option, Judge. He just wanted to come up, let you know what had happened, and hoping that you'd give him the deferred.
All right. Well, I'm not going to give you deferred adjudication. I am going to find you guilty. So the issue that needs to be discussed is with regards to the offer of a cap of 10 years and the sentence that I give him. There needs to be, I guess, an investigation or law needs to be pulled on what time he gets credit for.
Well, I would ask that he gets credit for all 5 years, Judge.
Your Honor, if I could just say something, technically he was not, an arrest warrant was never walked. He was, the first time a warrant ever went out for this case was when he was indicted for this case. So as far as speedy trial or anything like that, I mean, they didn't have enough to indict until they did a comparison. So it wasn't just the CODIS that he was indicted on. They did another swab.
See, but here's the thing, Judge. They had his name, they had his location. If they had done any real investigation, they would have been able to find that he took this plea in 2009 and was reported, you know, they had his DNA. So I understand their point, and this is one of the things that I explained to my client, because they did not walk the arrest warrant, but they knew all of the factors. And it wasn't like he went anywhere. It's not like he ran. He was there the whole time. In his mind, he had worked this all out, was going to prison so that when he was done, he could start his life anew, and he did. He is the poster child of our rehabilitation system. He got out. He reported like he was supposed to. He got himself a job. He got himself a community with his mom, his aunt, his neighbors. You read some of those letters. I mean, his daughters think the world of him, okay? Because from that point on in their world where he lived with them, he was the perfect father. He did everything he could for his children. And I submit to you, this is what we want from our justice system. We want people who make huge mistakes, and he did, Judge. He's not denying that.
Well, what I can tell you is the court thinks it's morally wrong. Notice I'm not using the word legally, but I think it's morally wrong for people, and I know it wasn't this prosecutor. I think it's morally wrong for people to know that people are at the prison, and then when people get out, then bam, we're dropping a case on them that's been in existence and been out there. And I know, Ms. Mitchell, you were not a part of that. So I am going to find him guilty. And if anybody wants to do research on what credit for time he should be entitled to, maybe we may be making some new law here. Let the court know, and counsel, if he is able to get credit for the time that he was at the prison. You say the 5 years.
Yes.
If you bring the court case law for that, the court will consider giving him time for the 5 years.
Yeah.
So if someone brings that to me, I will make sure that he receives that. Mr. Singleton, I'm going to tell you, I understand that you have changed your life, and it seems that you've changed your life for the better. And I understand that you thought that all of these cases were being taken care of when you took care of the other. I've read the stipulations. I always reread the stipulations, and I always read the PSI report. So I know the circumstances behind this. And I never blame complainants for anything that happens to them, because you're living your life. You're not breaking the law. Nobody's supposed to break the law where it impacts and hurts you. But I saw the circumstances behind everything that's in the stipulations. The drug use, which is the drug use by you, should not have happened because she's not be using drugs with her. The mother who is and father who are not watching her the way they should watch her. So there are a lot of things that would. Could somebody help Miss? Yes, with her phone. Thank you. So I understand there are a lot of issues going on, but at that same token, this is the plea bargain agreement you entered into. Okay. The court is going to find you guilty. The court will sentence you to 10 years in the prison. The court will give you credit for any time served and defense if you bring me documentation of the amount of time that he served in prison. And if the law says that I can give him that time, then of course he will receive that time. If you think he should get that time and you want to file an appeal on that for him to get that time, just let the court know. And I know you're court appointed. Is that correct?
Correct.
You can be court appointed to address that issue as well.
Thank you, Judge.
All right. Going to show you. Oh, and I'm sorry. There's also Chapter 62 registration. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I have
Yes.
one question.
Yes.
You said if they find out that I was already locked up, I was interrogated about this case out of Harris County. It said I have an audio tape interrogation out of Harris County about them questioning me about this case, about them calling here saying that we have him in custody in Harris County, out of Harris County on
Okay.
this case.
All right, counsel, do you have that information?
We have that information, Judge.
All right, so if you present that, and again, if based upon the law, if I'm allowed to give you credit for that, I will. Okay.
Yes.
I don't know offhand because I don't have all the information about who knew what and when they knew it. I know that you're saying that they knew it and your attorney's saying they knew it, but I actually have to see the evidence for that. And if that's presented to me, and if case law says that I can give you credit for that time, I will give you credit for the 5 years.
Yeah, because when they initially, before I initially turned myself in, I had the case out of Harris County and they told me I had a case pending out of San Antonio, which my DNA was a match in 2009. And when I turned myself in, I got the 5 years out of Harris County. I asked the judge, when were they going to send me back to San Antonio for this case? So I've been know about this case. I've been know about this case since 2009. And I thought that they would have came and expedited me, since they took my DNA at TDC after I took the time. And they took my DNA also when I got out of the walls.
Okay.
I never had a detainer.
All right. So Mr. Singleton, just give that information to your attorney. And again, if the case law says that I can give you credit for that, I will. All right. Thank you. 22 CR
hearing came to a close,
6777
was
State of
left
Texas
wrestling
versus
with two
Tremonte
difficult
Singleton.
truths.
Can I have parties announce for
one
the
hand
record for the
was a
state?
man who
Financial for
admitted
the
his
state.
past,
For the defense?
served prison
David A.
time,
Garcia, attorney for
stayed out of
Trayvon
trouble for
Singleton,
years,
Judge.
And are you
raised
Mr.
his
Singleton?
children,
Yes,
and
ma'am.
tried to rebuild his life.
According to the plea bargaining
On the
agreement,
other
punishment is to
was
be
a crime
assessed at a
so
cap of
serious
10
that the
years.
judge said she
The state
could not
opposes your
ignore it, no
application.
matter how much
Have both
time
parties had a
passed.
chance to review the PSI
Even the
report
court
state?
questioned
Yes,
why
Your
the case
Defense?
remained dormant
Yeah.
for so
All right.
many years,
Any
while
objections,
Singleton
state?
was already behind
Defense?
bars.
Judge, the only thing that I
Yet,
would
despite
add is
recognizing his apparent rehabilitation, the
it's
judge
left out
refused to
that
grant him the second
one of
chance
his
he desperately
priors was
wanted.
out of Houston.
Instead, she
And
found
it
him
was
guilty
indecency
and left one
where he
final
served
legal battle
5
unresolved.
years.
Whether
prison.
he should
Okay.
receive
I wanted to
credit for
bring
the
that up
years he had
because my
already
client can
served.
talk about that.
Was justice
Secondly,
delayed, still
when they
justice
asked about
served?
the
Or
incident,
did the system fail
because it was
everyone
21
involved?
years ago,
The answer
my
would leave
client was
viewers
kind of in
debating
shock
long
trying to
after the
remember, but
courtroom doors closed
and
behind
you'll
him.
hear from him.
The judge refused deferred adjudication and sentenced him to 10 years. But she left one door open, whether he should receive credit for the 5 years he already served. What do you think? Should that time count? Felony drug court is designed to be a second chance. But when a defendant appears before Judge Boyd, with 36 sanctions on her record, the judge has a difficult decision to make.
Hernandez was placed on deferred adjudication in 2020 CR 8599 for the offense of abandoning the intent to return on January 4th, 2021 for a period of 3 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violating condition number 13 on or about the 23rd day of April 2024 in Bear County, Texas. Defendant Victoria Hernandez did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13.
How do you plead to that, true or not true?
On the waiver of any violated conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand that?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 13?
I do.
Court will find violation of condition number 13 true. Is there a proposed agreement?
No, there's not.
All right, state, what are you requesting?
State's requesting revocation.
Defense, what are you requesting?
Your Honor, probation had made a recommendation to extend for 1 year placement as Hernandez in a DDRF, followed by mixed supervision and a parenting class. And as the court could see, she was in felony drug court. DDRF was held in abeyance last time as an option, and she is motivated to go to DDRF, be successful in it. Apparently, the wait is only 3 to 6 weeks, and that's what we're asking the court to do.
All right, any objection to the court reviewing the court summary?
No objection, Your Honor.
All right, Ms. Hernandez, I don't think you're a good candidate for probation. And let me just tell you why. Felony drug court is an intensive form of probation. I know that. But from reviewing the court summary, it's not as though felony drug court, you mess up one time or you make a bad choice one time that they say, oh, we're not going to deal with you anymore. And I'm looking here at the sanctions that they gave you over there. And let me just tell you how many sanctions they gave you, which means this is how many chances they gave you. You understand? So it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36. That's what you're coming to this court with. 36 times felony drug court was seeking to work with you. So you see where my mindset is? And do you understand why?
Yes, Your Honor.
And so I placed you on probation here. And even here, you had a motion to revoke filed against you. And that was on, well, it was heard on March 9th, 2022. And that's when you were sent to felony drug court. So I don't think you're a good candidate for probation.
Judge, if I could,
Yes.
one thing for Ms. Hernandez, the good thing about felony drug court for her was that it is our belief that it has worked. She has been clean since September, and if she was tested today, she's going to come up negative.
Mhm.
So, it's not like she totally, yeah, there's several things that she did do correctly in felony drug court. There are a number of things, obviously, as the court has seen, that weren't done correctly, but she's made a lot of her appointments, and she has ended up clean, which is the point of felony drug court.
I just don't think you're a good candidate. I mean, felony drug court, that's a very good program. And what felony drug court has placed, the issues they have with you, I mean, they're major issues, but instead they are still trying to work with you. And they tried to work with you a lot. Here's the thing. I know a lot of people want to stay on probation. They do. Like, nobody wants to go to prison. I don't take any joy in sending the people to prison. And everybody that I send to prison or everybody I place on probation, I actually do remember them. Even as a defense attorney, I had some clients who ended up in prison. Guess what? I still remember them and wondering how they're doing, and hopefully they've changed their life. And it'll be the same with you. I just don't think you're a good candidate for probation. I think we tried.
And
So,
And Judge, the only other thing is she's never been given a felony conviction before. That's why she wants to stay on defer. She's motivated for it. And that's why she was hoping that the probation's recommendation would be followed.
all right, this is what I'm going to do. I'm going to find 13 true. I'm going to revoke, find you guilty, and I'll sentence you under 1244. Does anybody want to state any objection to her being sentenced under 1244? All right, I'll sentence you under 1244. Let's talk about the time.
Yeah. How much time does she have? Anybody know? How about before all the past few years?
Judge.
Yes.
So I was going back and forth with the drug court personnel in this case, and there is some concern if she is given a sentence JSAT.
Oh, it's not going to be JSAT.
Okay. Okay.
All right. And what was the concern though? Now you've piqued everyone's interest.
Judge, they feel that a JSAT sentence is not the reason why she was kicked out of drug court and so forth. They just don't think JSAT would be appropriate. and some other concerns in regards to her child. So if she was given JSAT, they just have concerns in regards to that. Now, if she was continued, then that would be something different, but they are not in agreement with anything JSAT.
All right, so what is the issue with the child?
From my understanding, there is a CPS open case for neglect and possible abuse. Not on me, on the father.
Okay.
There's an open case.
And state you're asking for revocation?
Correct, Your Honor.
So we are not opposed to revocation, but we are not with JSAT.
Okay.
Judge, if
I mean,
may.
what I can tell you, I wasn't going to give her judgment satisfied. I just, let me just tell you what my thought processes were.
Yes.
My thought process in reading everything was I saw that there's a child involved, right? This case involves a child and it's abandoned with intent to return. So I understand, and I understand that that child, they're telling the report is special needs.
Yes.
But she's making horrible choices.
At the same time, Judge, if she goes to DDRF, it doesn't kick the can down the road. It puts her in a position where potentially she'll be a better citizen, better productive parent. So DDRF only lasts for long, probation only lasts for long. If we help her continue, she has a possibility of, one more chance. And the court has given plenty of chances before, but if she's given one more chance, there's a possibility that one day she's going to be still with this child, and that child needs a stable parent, and DDRF will help in that potentially.
State? Is the state still recommending revocation?
Well, Judge, little child involved, I mean, the state would be opposed to the follow-up and she is appropriate, hopefully, because it looks like the person from those that we have in our system, that the defendant might have any problems, and any type of additional help might help for the future of that child at least.
Well, I will tell you what. Your special needs child has saved you. And you are not saving your special needs child. So where is the child now?
He is with his father at the moment. The CPS case is on the father and the current girlfriend. And
so let me get this straight and correct me if I'm wrong. So you are saying that there's allegations of abuse, and those allegations are abuse against the father who he's with?
yes, Your Honor. And the case has been open for about they opened one CPS case, my court did, because of the what they had found in my phone. And then the caseworker got in touch with
what did they find?
Father.
Wait, raise your right hand for me, please. You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth.
Yes, Your Honor.
So help you God.
Yes, Your Honor.
All right.
So
State your name.
Victoria Hernandez.
What did they find in your phone?
So they found that, so I had found out that my kid's father was locking my son in the room, and I wasn't aware, so later on they said that it was because the autism doctor recommended that they lock the door at night, but I thought they were just locking my son in the room all day. And so that's what drug court found on my phone when they were going through our messages, was me getting mad at the dad about locking my son in the room. And so they called CPS for neglect. And then the dad got another CPS case because I believe the school called CPS for neglect as well.
All right. Any objection to somebody from drug court zooming in?
Objection.
No objection.
All right. Just have a seat. Drug court is going to zoom in so we can get to Mr. Garhan. I'll let you all continue to talk, but this is Miss Garcia. So she's going to give us information. All right. We're back on the record in 2020 CR 8599, State versus Victoria Hernandez. All right, so we have Officer Garcia by Zoom. Any objections to her being by Zoom? Defense?
No objection, Your Honor.
All right, and the state has already stated that they do not have any objections. Officer Garcia, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Do you waive any confidentiality that Ms. Garcia has as it relates to your time in felony drug court?
Her talking about.
Oh, no, I don't mind.
All right, so you're giving up that right.
Yes, Your Honor.
All right. Any objection to her testifying in the narrative?
No, Your Honor.
All right, Officer Garcia. What we're trying to discover is whether or not she should be revoked or whether or not I should send her to DDRF. What has transpired is there's been a mention of a child with special needs because I was inclined to sentence her to the Bexar County Jail under 1244 to 1 year. Can you tell us how she was doing? What have been the issues with her in the drug court? And what would be your recommendation for her?
Judge, Victoria was on my caseload the entire time that she was in felony drug court. As you saw in the court summary, we did work with her extensively. Every time there was a violation, we used progressive sanctions. We did have DDRF in abeyance, back on 9/20/2023. Instead of that, we went ahead and gave her the chance to do Alpha Home, which she did complete. However, she went right back to her old criminal thinking, people, places, the basics that we teach in felony drug court. We were working with her, and we happened to do a phone search only because there was another phone search done on another participant, kind of intertwined the two. And that is the only reason why we found out is like it fell into our lap. It wasn't something that we were looking for. And we had concerns, again, because of her special needs child. We do have another case against her in CPS. So the CPS case, there is one pending for the father of her child, and we do also have one for herself.
All right. Do you know, with regards to the case for herself, what is that about?
Because of what was found on her phone.
So what was found on her phone has absolutely nothing to do with the child's biological father?
It's actually both of them are involved. But again, he was the only one that the case had. The first CPS case is only on him. So when we found the information that included both of them, a CPS case was filed against her as well.
So what was on her phone? Did it have to do with, I don't want to get into too much, but what was on her phone? Did it have to do with her as it relates to her and her child?
Yes. Concerning for her to be around her child. Absolutely.
Okay.
And then considering her case that she's on as well. So with that being said, we have seen often that we work with the individuals and there wasn't really enough progress, and we don't feel comfortable with probation doesn't like to recommend revocation. But we have seen in drug court that a lot of our participants are getting credit for time served. So we didn't want her to just, get a JSAT and be done, because then there's no problems that are fixed. And then we have the concern for the son, because she will be able to go back and just be around him. That was what she was trying to do while she was on my caseload. So that is very concerning. If I could recommend revocation without the JSAT, I would. And I would like to. That's what I would like to happen.
All right. Do you have any questions?
I do, Judge.
All right.
Officer Garcia,
Yes, sir.
throughout her time throughout felony drug court, she tested negative on multiple occasions, correct?
She did. However, she also tested positive.
How long ago was that?
Let me check. Drug test. Well, she did have a no-show, so to us, that was April the 17th. That is considered a positive in felony drug court. Let's see, her last positive would have been September of last year.
2023?
Yes. And again, she did go to treatment during that time frame before we just got her back reporting in person.
That's all I have for you. Thank you.
Mhm.
All right. And Officer Garcia, you all are not willing to accept her back. Is that correct?
No, Judge. We worked so much with Miss Victoria, and it just seems like we hit a wall at this point.
All right. Thank you so much for zooming in on such short notice. I appreciate it.
Yes, Judge. You have a good rest of your afternoon.
Okay. All right. Bye-bye.
Bye-bye.
All right. So with her, it's going to be revocation. Are you still insisting that was not related to you?
I wasn't aware the second time around that a CPS case was put on me. I've been in jails.
No. My question is, are you still saying that what was on your phone regarding your child is unrelated to you?
No.
Okay.
Judge, in lieu of that, we're asking for the minimum time in law. Apparently she has 158 days in custody over the past 3-4 years. And I would argue that, she has done several things right. She's also done several things wrong, but there was several things. She did participate in the felony drug program and did a lot of good things. So we want the court to reflect on that.
All right. This is what the court is going to do. Court is going to revoke you. Let me see. Where is the trial court certification?
Handed it to the court.
I do have it here. The court is going to revoke you. The court is going to find you guilty. The court will give you credit for any time served. The court will give you credit if you successfully completed inpatient treatment, because I see there was some inpatient treatment maybe through alcohol. If you successfully completed that, the court will give you credit for that. And the court is going to sentence you to 2 years in the state jail facility. I'll recommend the therapeutic community. I can't force them to place you in there, but if you request it, they will consider it. If you don't request it, they will not consider it at all. And I'll also request mental health while she's at the state jail facility. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, we can go off the record. You're going to have to get your life in order. If you don't, your life is going to continue to spiral out of control. Felony Drug Court is a good program. They work with you for 2 years trying to help you, and you still just want to do whatever you've been doing, which is not good for your son. I always tell people, you're an adult. Your son is not an adult. Your son is 100%.
36 chances. What would you have done in this situation? Let us know in the comments. And stay tuned for more courtroom decisions.